copyrights protects the expression of ideas. An idea as such is not protectable. If you have an idea, everybody can have an idea, it's not protected. How to protect an idea? You have to express it. If you express it in any way, if you do it orally, you do it in written, you make a design, you make something, a painting, this is a form of expression. This act creates protection on its own. It is an exclusive right of the author to dispose of copies. It can be literally musical, artistic work. It can be a book. The content of the book, the ideas in the book, are not protected. The shape of the book, the way how it's written, the text as such, is protected. For example, a film, a movie, is actually not directly by copyright protection, but it's neighboring rights, which means you have the original author and they have the executor. So the production firms, that is the neighboring right. So it arises simply with the creation of the work, and the duration is 70 years after the death of the author. So if you create something now, it will your children or family who inherited from you will have rights to this copyright until 70 years after the death of the author, not after the creation. So also, what are the conditions of copyright? It arises simply with the creation of the work, but not everything that you create is protected by copyright. It has to be original. What is original? Original means that it has the stamp of the author on it, and it is an expression of the mind. For example, an expression of the mind means something that not everybody can just do. For an example of jurisprudence here in Brussels, you have the buses, drop on, drop off for Brussels tours. Somebody thought that this idea to have all these stops in Brussels was protected by copyright, and the court ruled, no, this is not. This is something everybody can invent and create. Then it also must have the stamp of the mind of the author. For example, this is the atomium. The atomium is something very special. You can make a building, but to make it in this way creates copyright. It's really original. It really is an expression of the thinking of the author. And then the last sign is also logiciel. Computer programs are also protected by copyright. And this third one is the movie. Yeah. So this is copyright, originates without you have to deposit. You don't have to do anything. Industrial property rights, ruled by the Paris Convention, are registered rights. First of all, patents. Patents provides for 20 years of protection for inventions that are non-obvious, useful, and that have not been already patented or publicly sold or used anywhere in the world. So the basic principle of patent protection is that it has to be novel. It's the principle of absolute novelty. This means that it must not be known anywhere in the world by any means, not orally, not written, not in publications, for science, not in speeches, nowhere. It has to be completely new. If it's not new anymore, it cannot be patented anymore. It has to be non-obvious. That means like the ingeniousness. It has to be something that is not for everybody who knows the field to understand it. So if you know the field, it's the normal person, it's the l'homme de métier in French, and it has to have an inventive step. And then usefulness is industrial applicability. So these are the basic principles, and actually patents can be obtained in all the fields of technology. There are no limits. So there is biotechnology. This is an example of the iron threads of Bekaert. It's a Belgian company that makes fences from iron and tears the iron. Yeah, lots of techniques are involved for which there are patents. This is like a modern technology for windmills, production of oil, and then the last one is an example of Atlas Copco. It's a machinery for vacuum machinery. So this is like the basic principle of patents. And to have a patent, you have to make a deposit. So from the 20 years starts to count from the day that you make the deposit of the patent, and then gives you some exclusive rights. Then you have also utility models. Utility models are like a sort kind of light patents, which are like just modifications for improvements or adaptations, and it provides for a maximum 10-year protection. This does not exist in all member states. As there are, in Belgium, for example, it doesn't exist utility models. Then there are trademarks. Trademark is also a very important intellectual property right. You know, everybody knows trademarks. You see here the examples. It gives a potentially unlimited protection. Every 10 years you have to ask for a new renewal. You have to pay fees, of course, and it has to stay on the market. And what is a trademark? It is a distinctive sign. Can be letters, words, can be logos or combinations. Can also be three-dimensional. For example, the Coca-Cola bottle, it's very much known. It has 3 dimensions. You can also deposit this as a trademark. Or words, or also services. Katrien guys, it's a coiffeur, a hairdresser service, and Starbucks coffee, and you see it says for products, and it's also for services. And what is the aim of trademarks? It is to protect the consumer from being deceived about the origin of the goods. So the origin is of course also connected with the quality. So if a consumer goes to the supermarket and he sees the product with this logo, he knows, oh, it's this product, I know this product comes from this company, and this product has these qualities. So if then, for example, there is another product next to it that's very similar in the way that it can confuse the consumer, and because it's not this product that he wanted to buy, but it's another one, but it's very similar, then it is a problem of counterfeit. So it is distinguish similar products from competitors. And then the design protection, it protects the shape, external shape of a product, or the configuration or pattern. This one that it came out, it's supposed to be a tissue from berries, like the lines. You have 2-dimensional and 3, maybe it comes here. Oh yeah, here it is. You have 2- and 3-dimensional designs. So this is a 2-dimensional design. It's more drawing, and 3-dimensional. It says a new product, and how you compare the novelty, you look at the overall impression that it gives, and you see what the informed user would he think, would he be confused that it would be the same product or another product? Would he think that the product he's buying is the product he wanted to buy or not? And the protection is maximum 25 years. It's 5 times 5 years, and then it's finished. So there is one intellectual property right that can last forever is the trademarks, and the others are all limited. And all the designs to deposit, you have to pay fees, you have to pay taxes every year or every 5 or 10 years to keep it. To ask for a patent, I don't know if to ask for a patent, there are different ways to do that. For example, there are the national patents, which have to be asked in every single country, because patents, it's national. If you ask a patent in Belgium, it's a patent within the territory of Belgium. If you ask for a European patent, it is for, it's through the European procedure, and then it becomes all different patents in different member states of the European Patent Convention, which are at this stage 40 members. It's not community, it's European, it's bigger. It's also with Switzerland, with Turkey, Liechtenstein, Norway, Iceland, and so on. So, and then you have also the international patent system registered by WIPO, and it's also a procedure through which you can obtain different patents in different member states. So it's very important to know, if you obtain a patent or a trademark in one country, you're not protected in the other country. So this is a fast introduction just on intellectual property. And then IP and enforcement. It's very important, if you have a law, if you have a protection, you also have to obey it and you have to enforce it. That's the basic of the protection of intellectual property. Enforcement is dealt with at national level, because intellectual property is national, except of course the community patent, which is one title for the whole community, and community design, as I said. But in national level, the policy can help to have enforcement by putting concrete objectives, putting national structures, raising awareness, like what I'm doing now, telling you, look, take care, there is intellectual property. Can put enforcement targets. Governments say, we want to have so many cases targeted for counterfeit. Legal and regulatory framework. It's under continuous construction and review to make legal and rules better. And there is a close cooperation with industry and governments to enforce intellectual property law. There are also cross-sectoral associations involved in anti-counterfeiting activities. Lots of private associations are set up because of the counterfeit problems. TRIPS is the third pillar of WTO. It's the basic of IPR and enforcement. It's a multilateral trade framework. Every country